Hey, everybody. You know what? This trial is over with, done with. If you turned on YouTube today and you said, "Where's the trial?" It concluded late last night, and I have got all of the concluding details for you. Stay tuned. You know what? The only thing that's more interesting than watching the gymnastics team finale at the Olympics with Simone Biles is watching the gymnastic team final with Simone Biles while you're waiting for a verdict. I kept looking at my phone, watching the balance beam, looking at my phone, watching the balance beam. And just as Simone Biles finishes her floor exercise, we have a verdict. Yeah, I'm not kidding. I actually switched it off because we knew at that point that the team had the gold medal. I switched it over to YouTube to find out how this concluded. And you're going to want to hear this because it's quite dramatic. Okay, state's closing argument. So there's two female prosecutors, a lead and I don't know that one was lead and the other. They both seem very experienced at what they were doing. So one did the first part, one did the rebuttal portion of the closing arguments. And this was lengthy, man. I don't know how they found so much to talk about, but they did. And I'm going to say close to 3 hours, with breaks and stuff for the closing arguments. So the first thing this prosecutor does, and if I haven't said it already, this is Ashley Benefield versus the state of Florida, or the state of Florida versus Ashley Benefield criminal trial for second-degree manslaughter. That means they have to prove that she had a depraved heart, some kind of hatred, ill will towards Doug Benefield, and she shot him. And then the defense has to say, they're saying, well, it's self-defense. So that's where we're at with this trial. She was a former ballerina, and we've been covering this for about 10 days now. Now, what am I working on this morning? More circles, more peppermints for the peppermint blanket, crocheting, yeah, and cleaning. This desk is clean. I'm ready to start the event tomorrow. I've got my diamond painting out. It's on the table. I haven't diamond painted in about 2 weeks. I'm ready to go. Ready to go. Okay, back to the trial. Closing arguments. State starts out by acknowledging domestic violence. Yes. Is it a thing? Yes, it's a thing. But this was not the defendant, nor was it ever the defendant. There was no domestic violence going on here. She said, does it happen? Are there cases where, the woman is justified in deadly force against her significant other? Yes, of course it happens, but that's not what happened here. And after hearing all of this, I tend to agree with them. They hadn't lived together in 3 years. So, first of all, that's not domestic. Just because you're married to the man doesn't make it domestic violence. Well, I guess by definition it does. But you're not even in the same house with him for 3 years. Anyway, Ashley had a goal, and the goal was to get sole custody at all costs. She was going to do what she had to do to get sole custody. And it's the jury's job is to look at what happened that day and say to themselves, was this reasonable? Was this necessary for her to get a gun out and shoot him 4 times? Now she says, listen, I'm not going to tell you Doug Benefield was an angel because, we know he wasn't. And we know that his behavior in South Carolina was unacceptable. In the kitchen that day, where he takes a gun out to shut her up from screeching, and he fires a hole in the ceiling, punches the drywall, punches the door. Was that acceptable? No. But he apologized. Now, when she said this, I cringed. I'm like, oh my God, she did not just say that. Because we know an abuser is always going to apologize. That's part of their, We know that. So why would she say that? But anyway, but he apologized. Like that's going to make it okay. That does not make it okay. If it's truly domestic violence. Yeah. Anyway. And maybe it was at the time and she did the right thing. She left him. And then 3 years goes by. Why do you keep going back to him? Anyway. So she talked about the South Carolina injunction. She said, don't read a lot into this injunction because the court never made any findings of fact with regard to one person or the other. It was actually, this injunction was agreed upon by both parties, both Ashley and Doug. They went to the court. They agreed, okay, we'll stay away from each other. Okay, here, we'll just write the order. So that's how that came along. And then she decides, well, when he goes from South Carolina, comes to Florida, she's like, okay, he's violated the restraining order by sending this present. And this present is poison. He's trying to poison me. She doesn't tell him about the birth. This guy was 6 months old before he even knew this child had been born. Or it was weeks before he knew the child had been born, 6 months before he saw the child. And then she doesn't even give him she doesn't give this child his last name. She gives the child her father's last name, her maiden name. And this prosecutor brought out the point that I was making. Who was the one controlling the situation here? Was it Doug or was it Ashley? Remember I said tables might have been turned here? And I think you got to look at it that way as well. Was she the one doing the controlling with this child, that she's waving in front of him? She knew that he wanted, more than anything, he wanted his family together. He wanted her, he wanted his child. So was she using that? I don't know. So the prosecutor went on to say she was using the criminal courts to control him, to control the situation, so she could get sole custody of this child. And then when that didn't work, because with this restraining order violation, when that doesn't work, she goes to the family law portion of the court system and try to see if that's going to work. And then when that doesn't work, she's like, I'm going to take matters into my own hands. And she does. So the jury doesn't know what this Florida judge actually said when she rendered her family law ruling against the restraining order. But this prosecutor just mentioned, oh, by the way, the restraining order that she asked for in family court was denied. And then the charade begins. He comes to see his child for the first time and she goes with him. And after that, everything for the next 11 months is hunky-dory. Yeah. And during this 3-year period of time, he doesn't hit her. He's not threatening her. He's not intimidating her. He's not coercing her. Nothing is happening during these 3 years. All of the stuff that she says happened was back in South Carolina before she got pregnant and left to go to Florida. And the only reason this charade ended is because, she kept saying, we're going to get back together. You're going to move in. And then he finds out she's seen another man. What? She's seen another man. How's he controlling her if she's seeing another man? Then the child abuse allegations start up. Yeah, because now all's not so quiet anymore. Now she's starting the child abuse allegations. So those don't work. All of those were unfounded. Then she fails in family court and she goes back to criminal court. And that doesn't work. So then she starts marriage counseling. And all this time she's giving him mixed signals. She said it was 17 days before the murder, when she told the doctor that she was going to take matters into her own hands. And then only a few days before the shooting, they go to this mediation, and the mediation ends before it even gets started because they agree to everything. Okay, we're just dismissing everything. So what was her plan going to be when court happened on that Wednesday? Whether you think it was for an injunction or whether you think it was because this doctor's report was being released, I mean, who cares? Either way, the gig was up. Doug was going to find out she was not serious about him moving in with her in Michigan, or where were they going? Maryland. So then this prosecutor talks about the wheel of misfortune, the wheel of power and control. She said there was no intimidation, no coercion, no threats. He was not isolating her. Obviously, she's seeing another man. He had no influence over her comings and goings. She lived without him. She lived with her mom and her baby. She was actually the one using the power and control over Doug. And the whole realtor thing, apparently she asked the jury, check the email that Doug sent to the realtor about this house, where he says, I have to check with my wife, Ashley, first. I thought that was interesting. So then she starts to go through the jury instructions and how they should come about at their decision, ways of getting through the instructions because they're lengthy. Then she talks about the date of the offense. Doug thought they were getting along. He's been texting her Bible verses every morning, conversing with her. We're dropping them, we're dropping everything at mediation. We're going to move in together. Our stuff is commingled in this truck. We're going in the same U-Haul to the same state. I mean, and she wasn't afraid of him. She didn't say, oh, Mom, Doug's coming over. Could you stay? And clearly Mom wasn't afraid of him. She takes the kid for a walk. So who's afraid of him? Then this prosecutor talks about methods that Ashley was using to avoid answering questions when she was on the stand. And one of those methods was to say over and over again, I don't know. And the other was to, hysterically cry when she didn't want to answer a question. And then she talked about how Ashley said that he hit her that day. Well, how did he hit you? That was one of the questions. She started crying, wouldn't answer, was it open hand, closed hand, and then she shows like 4 different pictures of Ashley, one when she was modeling and different points in time. And you don't see bruising on any of these pictures, none. Then she talked about, I wondered where this right-handedness came in. And she talks about how, if you get, because Ashley had said he was in a fighting stance in the doorway. So she said, when you think of a fighting stance, you think of, somebody's like this. And just before I even say anything, put your hands like that. Now, which one of your hands is, how did she call it? Is bladed away, is what she calls it. It's this one. It's your stronger hand, because you're going to hit him. That's the one you're going to hit him with when you're in a fighting stance. And he was right-handed. So if he's like in front of her and he's like this, how does he get shot over here? Anyway, just something she pointed out. She said it's more likely that he was in a position of self-defense, like he came in the door, saw the gun and went, whoa, hey, whoa. Probably that was more likely the scenario. Now, the defense gets up and says, this was a fundamentally flawed prosecution because their theory of the case changed. Well, the theory of the case changed because he's saying their theory was she committed this murder to avoid the report the psychological report coming out at the hearing on that Wednesday. But then they changed it to the injunction was going to happen on that Wednesday. Well, who cares? It doesn't make a difference. Something was going to happen that Wednesday to let Doug know that she had been duping him all along. Why? Was she controlling him? And he said, neither of these theories are supported by the evidence. I beg to differ. So then he talks about, tells the jury, listen, imagine how she must have felt sitting in that kitchen the day that he goes and gets a gun and fires it into the ceiling and then punches the dog unconscious. Imagine. Okay, well, she left. That was the right thing to do. And 3 years goes by. Okay. And then he brought out to the jury's attention that one of the pattern of behaviors of an abuser is to apologize. I told you she should not have said that. I would not have brought that up at all. Then he says the day that she said to the doctor that she was going to take matters into her own hands, the doctor actually asked her, what do you mean by that? And she said that she was going to go herself to the courts in South Carolina to get them to enforce the restraining order. That's what she meant by that. I got an itch. Does that mean something when you have an itch like that? Anyway. So, and then he talks about how Ashley was endured. One second. She endured an hour and a half of direct testimony and 2 hours of cross-examination. And during which time the state never landed a blow. Okay. Why is he saying this to the jury? I have no idea. Anyway, so he said the day that this happened, Doug, he was on a slow boil. That, this was his last hope of getting together with Ashley, and that he recognized she was leaving him that day. That she tried to de-escalate the situation, and he kept ignoring her, and his hostility was increasing during this whole encounter. Then he talks about how what he did to her that day was false imprisonment because he wouldn't allow her to leave. But here's something the state pointed out in rebuttal. They had a map of the home. In order for her to get this gun, she had to go, because apparently the encounter she's describing happens in the front of the home when she's trying to leave. She goes all the way to the back bedroom to retrieve her gun, which I thought was kind of interesting. The other thing, and every time I hear this testimony, I think about it. She talks about he body checked her, he hit her with a box, these different things. He hit, slapped her. But she talks about them happening in different places. Inside the truck, they're arguing. I don't think this was one long encounter, one short encounter. I think this was, I don't know. I don't want to make of it. I really don't. Because if it was in the truck, she could have got away from him. It was in the house. Why is she going all the way to the back bedroom to get a gun? And I don't know. Anyway. So the defense attorney says, I've walked hand in hand with Ashley throughout this trial, and I'm surrendering her fate to you. Okay. And then he said, manslaughter is a compromise, because manslaughter is a lesser included offense of second-degree murder. He says that's a compromise. She's either guilty of second-degree murder or she's not guilty of second-degree murder, and this was self-defense. One or the other, not manslaughter. So then the rebuttal happens, and the rebuttal was more to rinse and repeat of what they had already said first time out of the box. So he sends the jury out with the final instructions to begin their deliberations. And pretty quickly, they came back with a very, very good question. They wanted to know during Dr. Quintella's testimony. Now, he's the mental health therapist. He was asked by the prosecution. They wanted to know, I'm trying to find the actual, okay. He testified that Doug Benefield was domineering, super controlling, and dedicating and he was dedicated to wanting this to work. So, and I even wrote here what it was based on. They wanted to know, what is this based on? Was it based on his observations of Doug, or did he make that statement based on what Ashley told him? Well, you can't really answer that question because the only answer you can give the jury is you have to rely on your own memory of the facts of the case. But my memory is that and this would confuse the jury, when the question was asked by defense attorney Taylor, based on your observations, what did you think of Doug? And this is what he answered. But when the state got up on cross-examination, they asked him, was your opinion that Doug was domineering and super controlling based on what Ashley told you? And he said, yes. So the answer is both his observations and what she was telling him. Either that or he didn't hear the defense attorney say based on your observations. I don't know. So they continued to deliberate for hours. Like the whole Olympic thing was going on. And I kept looking and I'm like, oh my God, it's really getting late on the East Coast. Why are they still there? And actually, when they came back with that question, the judge had said, we're going to order pizza for you. He says, I can't give you steak and lobster, but we're going to get you something to eat and something to drink. So there were no more questions at about, I'm going to say about 9:30 Eastern time. They come back. We can't reach a decision. We're hung. So in that case, they have to give what's called an Allen charge, where it's like, go back, give it one more try. Well, the instruction is really more specific than that. You're supposed to go around the room and see what each person thinks and talk about it and give everybody the opportunity to speak. And there's a whole method to this instruction. So, but he says, before I send you back to deliberate, you need to decide. He said, it's getting late. Do you want to go home, get a good night's sleep, come back in the morning refreshed, or do you want to keep going tonight? So they go out in the hallway and they talk amongst themselves. They come back. They're like, no, we're going to keep going. And I had told my sister they're going to keep going because my recollection was that one or more of these jurors had something to do today that they couldn't get out of, had some previous engagement. I don't know if it was an appointment or something, because the judge had kept saying we need to get this trial done before Wednesday. And I really feel like the judge should have recognized that before choosing the alternates or dismissing the alternates. But in any case, they go back and start deliberating again. So now I'm watching Simone. She's on the floor exercise. And I am not kidding you, like 45 minutes later, Simone Biles wraps up the floor exercise, and I see the bailiff come in saying, they've got a verdict. I'm like, what? Okay. And I looked at my sister and I said, this is going to be a compromise. It's going to be manslaughter. This is a compromise. And not because that's what the state had said, it's just based on my knowledge of these trials, that when a jury wants to get out of there and go home, they're going to compromise. They didn't want to, it was late. They didn't want to be there anymore. They didn't want to come back the next day. They were done with this. And the best way to do it is to compromise.
I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately throughout the trial. I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict, and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact, our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected, even if you don't understand it or don't agree with it. You ready to bring in the jury?
Yes, sir.
All right, bring them in. All right, you all can have a seat. Members of the jury, I understand you have a verdict. You have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it, make sure it's in proper form. Thank you. All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in Fort Manatee County, Florida, the state of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024 at Bradenton, Manatee County, Florida. Cheryl foreperson.
Would either side like the jury polled? State? Defense?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors.
I'd love to have been a fly on the wall for that one. And manslaughter, all they had to do was say that she, what was it? Was her actions reasonable and necessary? And they were not. The jury said, no, her actions were not reasonable and necessary. And she shot him in the heat of passion. That's it, in other words. Yeah. They didn't talk about ill will, depravity, because that's all second degree murder. In here, they just said heat of passion. Okay. So they come back and they find her guilty of manslaughter. Just like I predicted, manslaughter. And so then I said, he's going to ask for her bond to continue because she's out on bond. She's been out on bond for 4 years. This child is now 6 years old. She's had the luxury of being with this child for 6 years that she didn't give that luxury to Doug. And she wants to continue because this, little outing of hers until the sentencing, which the judge had said probably is not going to be for a couple months because it takes a while to get a pre-sentence investigation done in Florida. He says 6 weeks to 2 months to get those done. So, and you can't have the sentencing until after that. So Mr. Taylor, to the defense attorney, he made his argument that, she's a good citizen. She's not going to flee. She's law abiding, blah, 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 blah. And the whole time, Ashley Benefield is sitting there writing furiously. She's writing something in her notebook. And I'll tell you what that is in a second. But so when he finishes his argument, state, do you want to be heard? No. So the judge says denied. I'm remanding her into the custody of the sheriff. So she has to get up, handcuffs are slapped on her, and she's taken from the courtroom. And not one single tear, which I do want to say that the state did talk about during their closing. Did you ever see a single tear come from that woman's eye? No tears. And I talked about ugly cry versus regular cry, nothing, no tears. And so denied. She's in custody. So we will wait for the sentencing to occur in a couple months. And then I noticed mom was not in the courtroom for the verdict. Her mother wasn't there. Now, her mom's been there pretty much all during the testimony, but mom wasn't there. So I very much suspect she was writing a letter to her mom in the notebook, because before she's taken off with the sheriff, she tells the lawyer something and she pushes a notebook towards him. So I'm pretty sure she was writing a letter to her mom. And yeah, that's how it ended. So here's my thing. Would they have gotten to this compromise had they not had to be somewhere the next day? And they could have had the night refreshed, come back the next morning, and started in again. I mean, we'll never know, because you don't know what goes on behind the jury unless somebody wants to give an interview, and I don't know that anybody has. But yeah, crazy, huh? All right, so that's it, guys. Have a wonderful day, and I will see you tonight in Crafting and Crime Daily. That's at 6 I'm sorry, 7 p.m. Central Time. And I hope to see you guys then. Have a wonderful day, everybody. Take care. Bye.